What is Republic Act 10175? RA 10175 is an act also known as Cybercrime Prevention Act of 2012. The Philippine Congress enacted the Cybercrime Prevention Act of 2012, which addresses entirely crimes committed against and through the computer system. Under Section 4 of the law, the following acts constitute the offense of cybercrime punishable under the Act. Offenses against confidentiality, integrity, and availability of computer data and systems. Illegal access, illegal interception, data interference, system interference, misuse of devices, cyber squatting, computer-related offenses, computer-related forgery, computer-related fraud, computer-related identity theft, content-related offenses, cybersex, child pornography, unsolicited commercial communications, and libel. And lastly, other offenses. Other offenses include aiding or abetting in the commission of cybercrime, as well as attempt in the commission of cybercrime. What does it mean? This means that any person who willfully abets or aids in the commission of any of the offenses enumerated in the Act shall be held liable, except with respect to Sections 4C2 on child pornography and 4C4 on online libel.
Salient points of the Act. Cybersex under RA number 10175 is committed by any person who shall willfully engage, maintain, control, or operate directly or indirectly any lascivious exhibition of sexual organs or sexual activity with the aid of computer system for favor or consideration. The element of engaging in a business is necessary to constitute the crime of cybersex. Hence, to be held liable for cybersex, the person engaged in cyberpornography must not be a trafficked victim or child. For child pornography, if the person engaged in cyberpornography or prostitution is a child, it is submitted that she is not liable for cybersex under RA number 10175, since under RA 7610, a child abused or exploited is considered a victim. But the customer of the child exploited in cyber prostitution can be held liable for cybersex. How about cyber libel? Online libel is simply libel in its traditional sense, committed through a computer system or any other similar means which may be devised in the future. In other words, the traditional elements or requisites of libel still apply. The following are the elements of cyber libel based on Section 4C, subparagraph 4 of RA 10175. In relation to Articles 353 and 355 of the Revised Penal Code. First, there must be a defamatory imputation, meaning to say, there must be an imputation of a crime or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance. Second, the imputation must be made publicly, which requires that at least one other person must have seen the libelous post, in addition to the author and the person defamed or alluded to in the post. Third, the imputation must be malicious, which means that the author of the libelous post made such a post with knowledge that it was false or with reckless disregard as to the truth or falsity thereof. Fourth, the victim must be identifiable, which requires that the post must identify the person defamed, or at the very least, the person defamed is identifiable by a third person. And lastly, the imputation was done through the use of a computer system or any other similar means which may be devised in the future.
Who are the persons liable for cyber libel? It must be noted that the revised penal code punishes the person who shall publish, exhibit, or cause the publication or exhibition of a libelous post, or the editor or business manager of a book, pamphlet, newspaper, magazine, or serial publication containing the libelous material. In relation to the crime of cyber libel, you have two personalities that are clearly subjected to liability for the crime. First, the author of the libelous post, which includes the person who shall publish, exhibit, or cause the publication of the libelous post. The person who created the libelous post would fall under this category. Second, the editor or business manager in case the libelous post is contained in a book, pamphlet, newspaper, magazine, or serial publication. What is the penalty for cyber libel? Traditional libel is punished under the revised penal code as amended by Republic Act No. 10951, and the offender shall be punished by prisión correccional in its minimum and medium periods, or a fine ranging from 40,000 pesos to 1,200,000 pesos, or both, in addition to the civil action which may be brought by the offended party. Since the crime of traditional libel is punished under the revised penal code and under the Cybercrime Prevention Act if the crime is cyber libel, the penalty to be imposed shall be 1 degree higher than that provided for by the revised penal code as amended. The penalty imposed will be prisión correccional in its maximum period to prisión mayor in its minimum period. Prisión correccional in its maximum period involves imprisonment from 4 years, 2 months, and 1 day to 6 years. On the other hand, prisión mayor in its minimum period involves imprisonment of 6 years and 1 day to 8 years. Thus, the penalty for cyber libel based on the penalty under the revised penal code for traditional libel and computed under Section 6 of the Cybercrime Prevention Act of 2012, which increased the penalty by 1 degree higher, is 4 years, 2 months, and 1 day to 8 years. Thank you for listening.